Before I begin, I had mentioned this extensive commentary on Mitis Iudex by a young, very well-respected canonist, a laywoman in Italy, Professor Geraldina Boni, B-O-N-I, and some of you went online on her, Googled her, and the articles didn't appear, and I'm a little surprised. I saw that too. Then I went to get my original email from her, and it's in 3 parts, and it's found on a website, www.statoechiese, STATOECHIESE .it. And if you go on there, and then it says authors, go on, click authors, you'll find Geraldina Boni, and she has a number of texts on there, but the text you want is La presente riforma del processo di nullità matrimoniale, problemi, criticità, dubbi. And it's in 3 parts. The first part was published on March 7th of last year, the second part on March 14th, and the third part on March 21st. It's really a heavy-duty analysis, so I commend it to you. And she's not some kind of extremist or strange person or anything. Just to give you a little idea, she sent it to me. I was blessed to get to know her at the time of a publication of a book of essays in honor of a professor of mine, a layman, Piero Antonio Bonet. He taught us the introduction to civil law. But anyway, she says that many people have thanked her from various parts of the world. And she says, my criticism is clear and hard, but I retain that these laws, Mitis, Iudex, and also for the Eastern churches, are among the worst ever promulgated. And she says, but please believe me that it's only my concern for marriage and my love for the church which have pushed me or inspired me to write with tones so strong and without any, what should we say, decorations, or it's straightforward. In fact, I don't like to expose myself, and neither am I inclined to polemics. But the moment is critical, and we must assume our proper responsibilities. So this is the kind of person that you're talking about, but you'll find it's a very serious analysis. It's not some, in fact, I made a couple of photocopies of this that has the connection if anyone needs it, but that which I gave you now, you shouldn't have any trouble finding it. Okay, now before we have our open forum, or I can't remember the exact title of it, we will have I want to give this presentation on error of law, open forum. But anyway, the error of law is a ground of nullity of marriage. This fits in a bit with our discussion this morning of that famous Article 14, paragraph 1, with those various presumptions of fact. During the plenary session of the Supreme Tribunal of the Apostolic Signatura, held on November 15th and 16th of 2007, in which I then, Archbishop of St. Louis, was privileged to participate as a member, the Fathers of the Apostolic Signatura revealed in detail the final draft of the Lex Propria or proper law of the Supreme Tribunal, which had been in the process of drafting for several years. By the conclusion of the plenary session, the fathers were able to approve the proposed text in each of its articles in order to present the text to His Holiness Pope Benedict XVI for final revision and approval. The Roman Pontiff approved, decreed, and established the Lex Propria, as it is called, on June 21st, 2008, with his apostolic letter given motu proprio, Antiqua Ordinazione. During the meeting of the plenary session in November 2007, the Fathers expressed the strong desire to have the opportunity to treat from time to time general questions regarding the correct administration of justice in the Church. Their desire was rightly founded on the truth that justice, although not sufficient for the fullness of our life in the Church, is the minimum requirement of charity. In other words, the Fathers were concerned that the Church's teaching on charity as the fullness of our life in Christ would make little sense if the Church did not take care to serve justice. Article 112 of the Lex Propria, which is part of the norms regarding the Apostolic Signatura's competence of vigilance over the correct administration of justice in the Church, reads, "It belongs to the Fathers of the Apostolic Signatura, together with the Secretary, to examine the text of a general executive decree or instruction prepared in Congresso and to approve it, and to treat general questions regarding the correct administration of justice." In fact, during the first plenary session after the promulgation of the Lex Propria, held on February 3rd and 4th of 2011, the agenda included the discussion of the following matters pertaining to the administration of justice in the Church: the first stages of the process in contentious administrative causes before the Apostolic Signatura, the conservation of the judicial acts of a cause at the local tribunals after the decision of the cause, and third, the correct jurisprudence to propose to the local tribunals on the error of law as a ground of nullity, error juris, as a ground of nullity of marriage, as it is treated in Canons 1096 and 1099 of the Code of Canon Law. Regarding the third matter for discussion, the Apostolic Signatura, in its study of definitive sentences from various tribunals, had for some time noted serious deviations from the common rotal jurisprudence in the matter of error of law as a ground of nullity. Given the seriousness of the matter, touching upon the sacred reality of marriage and the family as the first cell of the life of the Church, it was judged opportune to have the Fathers discuss the matter during the plenary session of February of 2011. The Fathers received in advance a lengthy votum prepared by one of the Fathers regarding the question. The Father in question was the eminent Cardinal de Lazo de Paulis. I would ask you to keep him in your prayers. He's recently had a surgery for the removal of a tumor from his brain, and he's not been doing very well. He's an outstanding canonist and cardinal. The votum was discussed at length during the plenary session. In order to assist with the administration of justice, which many of you either carry out directly or for which you have some responsibility in your diocese, I present you the fruits of the discussion of the Fathers of the Apostolic Signatura for the promotion of the correct jurisprudence regarding error of law as a ground of nullity of marriage in the tribunals of the Universal Church. The Apostolic Signatura, in fact, charged with promoting a correct administration of justice in the Church, when necessary, offers clarifications to local tribunals concerning the ground of error of law, drawing upon the work of the plenary session. My presentation follows in great part the order of the observations of the Fathers of the Apostolic Signatura as they were discussed and confirmed during the plenary session held on the 3rd and 4th of February of 2011. These observations are communicated regularly by the Supreme Tribunal to the local tribunals, so that causes of nullity of marriage introduced on the ground of error of law may be judged correctly. Error of law in general. The Code of Canon Law treats the effect of error upon a juridic act in general in Canon 126, one of the general norms on juridic acts. The canon reads, "An act placed out of ignorance or error concerning something which constitutes its substance or which amounts to a condition sine qua non is invalid." The norm clearly distinguishes between error about the substance of the act, which always renders it null, and error about anything that does not pertain to the substance to the act, which only renders the act null when the erring person makes it a condition sine qua non. That is, something without which the erring person would not place the juridic act. In the second hypothesis, one must prove not only the existence of the error, but also its reduction by the erring person to a condition sine qua non. The canon adds, otherwise, the act is valid unless the law makes other provision. There is a final clause of the canon about the possible rescission of the act made out of ignorance or error, and clearly it has no import for the act of marriage consent. The text of Canon 126 does not differ in content from the text of Canon 104 of the Pio Benedictine Code of Canon Law, even if the redaction of the two texts is somewhat different. Canon 104 of the Pio Benedictine Code reads, "Error renders an act null if it concerns that which constitutes the substance of the act or redounds to a condition sine qua non. Otherwise, the act is valid unless something else is provided by law. But in contracts, error can give place to a rescissory action, taking back action according to the norm of law." In other words, an error can accompany a juridic act and not render the act null as long as it does not concern what constitutes the substance of the act or is not a condition without which the actor would not place the act. Such concomitant error does not render the act invalid. But the legislator affirms in a general way in Canon 126 regarding the effect of error on a juridic act. He specifies for what pertains to the juridic act of matrimonial consent in Canons 1096 to 1099. He treats specifically the effect of error iuris, or the error of law, on matrimonial consent in Canons 1096 and 1099. If a marriage is alleged to be null because of error of law, the cause must be heard with explicit reference to the norm contained in those two canons. Error of law in marriage consent. Canon 1096, section 1 states, "For matrimonial consent to exist, the contracting parties must at least not be ignorant that marriage is a permanent partnership between a man and a woman ordered to the procreation of children by means of some sexual cooperation." Thus, ignorance and consequently error, which concerns the essential content of the act, that is, consent to a permanent heterosexual union, which is by its very nature procreative through the sexual cooperation of the parties, always invalidates consent. The only relevant error of law regarding marriage consent concerns the essential content of the act of consent as described in the canon. Canon 1082, section 1 of the 1917 Code of Canon Law, is identical in substance to Canon 1096, section 1 of the 1983 Code of Canon Law. It reads, "In order that matrimonial consent may be possible, it is necessary that the contracting parties be at least not ignorant that marriage is a permanent society between man and woman for the procreation of children." The following differences are noted but do not present a change in the legislation. This is all a presentation, obviously, of the natural law. This is not positive law. First, the 1917 Code of Canon Law describes marriage as a permanent society, whereas the 1983 Code of Law describes it as a permanent partnership. I don't think there's any substantial difference between those two terms. Secondly, the 1917 Code of Law describes the essentially procreative nature of marriage in language similar to the 1983 Code, but it does not make specific reference to the means of procreation, that is, some sexual cooperation. The presumption of the law in the matter must also be noted. Both Canon 1082, Section 2 of the 1917 Code, and Canon 1096, Section 2 of the 1983 Code state the presumption with identical language, and this is the presumption. This ignorance is not presumed after puberty. With regard to the presumption of the law, it is helpful to observe that nature itself teaches the essence of marriage. Even in a society which is marked by so much confusion and error about the essence of marriage, it must be presumed that the natural law and conscience will continue to attract the individual to the truth about man and woman and marriage and the family. Excuse me. Excuse me. In the same line, therefore, Canon 1099 states the general principle that an error about the essential properties of marriage, that is, unity and indissolubility, or the sacramentality of marriage between the baptized, as long as it does not determine the act of the will in marriage consent, does not invalidate the marriage consent. It reads, error concerning the unity or indissolubility or sacramental dignity of marriage does not vitiate matrimonial consent, provided that it does not determine the will. There are many people who have strange ideas about marriage, but they don't affect their own consent. They make a consent to marriage as God created it from the beginning. When error regarding the essential properties or the sacramentality of marriage determines the will, a situation similar to simulation presents itself. The party positively excludes an essential property or sacramentality because of his erroneous thinking about the property or sacramentality. It must be observed that for the valid celebration of marriage, it is not required that the will of the spouses include the essential properties of marriage or its sacramentality. We discussed that this morning. For valid marriage, it's not required that a person have a certain amount of faith in sacramentality. All that's required is that they will to marry, because it is the natural marriage which is elevated by the sacrament, and the party is imbued with the particular grace to live marriage. Because these do not depend on the will of the spouses. Whoever desires to give marriage consent naturally desires also the properties of marriage just mentioned and its sacramentality, because they are inseparable from it. Indeed, for the validity of juridic acts in general and the act of marriage consent in particular, it's never demanded that the individual party to the consent have either an exhaustive knowledge of the nature of the juridic act which he is placing, or a detailed knowledge of the concrete object of the specific act which he is placing. If such were required, the placement of juridic acts would become nearly impossible. In particular, marriage would no longer be available to all persons, including those who, in the often confusing situations of contemporary society and culture, follow the natural inclination to marriage, knowing in an intuitive way its distinctive essence or substance. Canon 1099, therefore, in accord with the general principles regarding the placement of juridic acts, denies an inherently invalidating effect to error, either regarding the essential matrimonial properties of unity and indissolubility or regarding its sacramentality. If the situation were otherwise, the state of marriage in society in general and the church would be completely destabilized. Canon 1084 of the Pio Benedictine Code of Canon Law contains substantially the same legislation. It reads, simple error regarding the unity or indissolubility or sacramental dignity of marriage, even if it is the cause of the contract, does not invalidate matrimonial consent. The 1983 Code makes more explicit the sense of simple error, that is, error which is in the mind but does not determine the will. It can happen that an error, if it is long-standing and firmly held, can have the effect of determining the act of the will in marriage consent to the point that one wills, for example, a dissoluble marriage and thus an invalid marriage. This is the meaning of the clause, as long as it does not determine the will, in Canon 1099 of the 1983 Code. In such a case, however, it is not the error, this is important for us to keep in mind, it's not the error that causes the invalid marriage, it's the determination of the will that causes the invalid marriage. This possible determination of the will in any case must be sufficiently and properly proved. It is necessary in such a case that the error reach such intensity as to condition the act of the will, thus causing the consent to be null, according to the words of Pope St. John Paul II in his allocution to the Roman Rota of the 29th of January 1993, or that it have a determining influence on the will's decision, as the same saintly pontiff emphasized in his allocution to the Roman Rota on the 21st of January 2000. Error determining the will. In order to understand better the content of the norm regarding error determining the will, it will be helpful to consider at greater length what St. John Paul II enunciated in his allocution to the Roman Rota of 2000, the one to which I just referred, January 21, 2000. Namely, that an error, even if deep-seated, for example, because of the widespread acceptance of divorce in today's society, does not in and of itself make the consent null. The only manner in which it can render the act of marriage consent null is by determining the will in a particular case so that the contracting party wills a marriage lacking, for example, indissolubility. Pope John Paul II declared, "No one can deny that the current mentality of the society in which we live has difficulty in accepting the indissolubility of the marital bond and the very concept of marriage as the covenant by which a man and a woman establish between them a partnership of the whole of life." The reference is to Canon 1055, Section 1. Whose essential properties are unity and indissolubility, which in Christian marriage obtain a particular firmness by reason of the sacrament. And there is a reference to Canon 1056. But this real difficulty does not amount sic et simpliciter to a concrete rejection of Christian marriage or its essential properties. Still less does it justify the presumption, as it is unfortunately formulated at times by some tribunals, that the predominant intention of the contracting parties in a secularized society, pervaded by strong divorce currents, is to desire a dissoluble marriage, so much so that the existence of true consent must instead be proven. Sadly, this is the kind of discourse that I heard not infrequently during that 2014 extraordinary session of the Synod of Bishops. The statement that today it must be presumed that Many, even 50% or more of marriages, are null simply because of all of the wrong thinking that is pervasive in society. Pope St. John Paul II continues, in conformity with the doctrine constantly professed by the Church, therefore, we must conclude that opinions opposed to the principle of indissolubility, or attitudes contrary to it, but without the formal refusal to celebrate a sacramental marriage, do not exceed the limits of simple error concerning the indissolubility of marriage, which according to canonical tradition and current legislation does not vitiate marital consent. Nevertheless, in virtue of the principle that nothing can replace matrimonial consent, Canon 1057, an error concerning indissolubility by way of exception can have an invalidating effect on consent if it positively determines the will of the contracting party to decide against the indissolubility of marriage. This can only occur when the erroneous judgment about the indissolubility of the bond has a determining influence on the will's decision because it is prompted by an inner conviction deeply rooted in the contracting party's mind and is decisively and stubbornly held by him or her. What is clear in the Holy Father's explanation is the distinction between an idea of the mind and an act of the will. In treating marriage consent, an idea of the mind, which may be erroneous, only affects the validity of the consent when it is reduced to an act of the will. Regarding error about the sacramentality of marriage, St. John Paul II provides critical teaching on the norm of the law in his allocution to the Roman Rota of the 30th of January 2003. You can see this notion was very much present in the discussion among canonists in the Roman Rota and very much on the mind of Pope St. John Paul II. Regarding the error about the sacramentality of marriage, he declared, "One cannot posit, alongside natural marriage, another model of Christian marriage with specific supernatural requisites." That's what we talked about this morning. This truth should not be forgotten when delimiting both exclusion of sacramentality and determining error about the sacramental dignity of marriage as possible grounds of nullity. In both instances, it is crucial to keep in mind that an attitude on the part of those getting married that does not take into account the supernatural dimension of marriage can render it null only if it undermines its validity on the natural level on which the sacramental sign takes place. It is clear that error regarding the sacramentality of marriage cannot be construed as requiring some knowledge beyond the substance of marriage as established in creation. If somehow error about the sacramentality of marriage renounded to error about the unity or indissolubility of marriage, and such error determined the will, then only could error about sacramentality be said to vitiate consent. In fact, the error which vitiates the consent is error regarding the substance of the act of consent which the party in question somehow links with the sacramental nature of marriage between the baptized and excludes by a positive act of the will in the juridic act of marriage consent. So that's the substantive law regarding error of law. Now the judicial proof of error of law determining the will. In keeping with what is set out in the Code of Canon Law and is illustrated by the Papal Magisterium, proof of the invalidating influence of error of law necessarily includes establishing the existence of the error of the mind, the idea of the mind, which is erroneous. We have to establish that first. The error of the mind, either regarding the substance of marriage or the existence of the existence of the error of the mind either regarding the substance of marriage or the existence of the error of the mind regarding an essential property or sacramentality which has been reduced to an act of matrimonial consent excluding an essential element or property. In tribunal practice, in order to prove the invalidating effect of an error of law on marriage consent, that is, error regarding the unity and dissolubility or sacramentality of marriage, it is not enough to verify the presence of the error in the mind of a party or to prove that the party was prone to share the contemporary divorce mentality. Also, error of law invalidating marriage consent is not proven because the judge perceives that the party had an understanding of marriage far different from the church's understanding or could not intend marriage as a communion of life. This is language that's actually taken from decisions which I had occasion to study while I was working at the Apostolic Signatura. The above language is all taken from the actual decisions declaring the nullity of marriage on the ground of error of law. Here it is necessary to note that the rite of marriage itself, because of its various references to the substance of marriage, and again, I'm repeating myself a bit from this morning, makes it difficult to postulate that one or the other party was in error about the essence of marriage. When marriage is celebrated according to the Catholic liturgical rite, it is much more unlikely that there was an error about the essential properties of marriage in one of the parties. In any case, besides proving the existence of an error regarding an essential property or sacramentality, one must prove that the erring person, in one way or another, willed his or her own concrete marriage to exclude the essential property or sacramentality. Therefore, it must always be proven that the error of mind in question had, in the concrete case, a determining influence on the will of the party when he gave marriage consent. In this context, one must not forget that the will is not necessarily determined by the mind. A person may think many things which are erroneous, but that does not mean that he intends those things in a concrete act. His erroneous thinking may not, in fact, determine his will in a particular matter. In the case of marriage, the state of being in love, for example, by its very nature moves the parties toward a total relationship, including perpetuity and exclusivity. Consequently, even if it is possible that two young people who love each other can in some way participate in the divorce mentality of the time, such thinking does not necessarily affect their concrete relationship, which they will naturally want to endure. The presumption is that such an intention formed in accord with the natural law is present at the moment of the celebration of the marriage. Now, the structure of the proof. The structure of the proof of the error of law, which invalidates matrimonial consent, will necessarily be different in the case of error of law treated in Canon 1096, Section 1, and the error treated in Canon 1099. In the case of Canon 1096, Section 1, it is necessary to demonstrate the error regarding the substance itself of marriage. The proof of the error of law regarding an essential property of marriage or the sacramentality of marriage must proceed in two stages. First, it is necessary to prove the error of the mind regarding the essential property or sacramentality. The proof of the error of the proof of the error of law in the mind, however, does not suffice for establishing the alleged nullity of consent. It must be shown that the error of the mind determined the will in the concrete act of consent. The schema of proof which Rodal jurisprudence has articulated is the same as the schema of proof of simulation of marriage consent. First, there is direct proof, which includes the confession of the party for whom the error of law has allegedly invalidated his marriage consent, and declarations of witnesses which verify the confession of the party. So that would be direct proof. It's not always possible. Secondly, there is indirect proof, which includes the reason for contracting an invalid marriage, that is, the proven reasons why the party has reduced the error of mind regarding the substance of marriage to an act of the will, and yet at the same time contracted marriage, together with the circumstances before, during, and after the marriage which confirmed the alleged reduction of the error regarding unity, indissolubility, and sacramentality to an act of the will. Canon 1099 lists only 3 possible objects of error determining the will: indissolubility, unity, and sacramentality. An extensive interpretation of the object of such error, which would extend, for example, to the marriage itself, to the good of offspring, or to the good of the spouses, is not permitted. Canon 1084 of the 1917 Code of Law also lists only 3 possible objects of simple error, that is, unity, indissolubility, and sacramental dignity. So it can't be extended to some global idea about marriage, or to the good of offspring, or to the good of the spouses. Actually, the question of the good of the spouses, as far as I have been able to determine, is simply, I can't find anything other than the 3 goods, the 3 classical goods. I can't find an additional good that would be the good of the spouses. It's the 3 essential goods of marriage that also constitute the good of the spouses. In the formulation of the dubium, the doubt, the ground, the judge must indicate also the object of the alleged error determining the will. For example, here would be the formulation of the doubt, an example. Whether the nullity of the marriage has been established because of error determining the will regarding indissolubility, according to the norm of Canon 1099, on the part of the petitioner. The use of generic formulations of grounds of nullity, such as error iuris, without any further specification about the object of such error, is not a correct judicial practice and does not help at all in reaching moral certitude about the nullity of the marriage in question. In the same way, when preparing the annual report of the state and activity of the tribunal, to be sent to the apostolic signature in January of each year, the specific ground of nullity based on error of law determining the will in accord with the norm of Canon 1099 should be listed. In other words, shouldn't just list error of law and how many cases were heard and decided, but error of law regarding the indissolubility of marriage. In listing the number of marriage causes heard under the ground of error of law as it is treated in Canon 1099, it should be noted, for example, error of law regarding indissolubility or error of law regarding unity. It is my hope that these few observations regarding error of law as a ground of nullity of marriage, which Canon 1096 and 1099 set forth, will be of some assistance to you in treating causes of alleged nullity of marriage because of error of law. In a particular way, I trust that will help you to distinguish, or has helped you to distinguish, between an error of the mind and an error which determines the will. I conclude with the words of St. John Paul II in his allocution to the Roman Road of January 3rd, 1993, in which he cautioned judges lest they depart from the sound principles of the law developed down the Christian centuries in order to make the law serve some particular agenda. He declared, specifically in matrimonial matters, the attempt at a none too well defined humanization of canon law must not depart from these principles that have also been sanctioned, as we have seen, by the same positive norm. With this line of reasoning, in fact, there is frequently an intention to endorse its excessive relativization, as if to impose, so as to safeguard alleged human needs, an interpretation and application of the law that thus ultimately perverts its characteristic features. Correlating the majesty of canon law with those to whom it is directed is certainly not to be omitted or underestimated. However, this entails the need for a proper knowledge of the Church's legislation, but without forgetting, in the light of a correct Christian anthropology, the reality of human beings for whom it is intended. Subjecting canon law to capricious or contrived interpretations in the name of an ambiguous and indefinite humanitarian principle would mean destroying the very dignity of the humans even before the norm. Thus, to give an example, it would cause serious harm to the stability of marriage, and so to its sacred nature, if the fact of simulation was not formulated concretely on the part of the alleged simulator, in a positive act of the will, or if the so-called error of law regarding an essential property of marriage or its sacramental dignity did not acquire such intensity as to condition the act of the will, thus causing the consent to be null. In other words, to fail to see the difference between an error of the mind and the determination of the will in a concrete case is an ultimate lack of respect for marriage itself. And as I said, if this kind of thinking were to prevail, marriage would simply be destabilized. I don't know who could trust that he or she was in a valid marriage. And at the same time, it does not show the proper respect for the dignity of the persons contracting marriage. In other words, they could have an error of the mind, but in the act of consent, that does not at all determine their will. I remember when I had finished my studies of canon law and I returned to the diocese to work, and I was still helping out in a parish and doing some marriage preparation, and there was this one couple. The young lady had been a student of mine when I was a high school teacher, and she was marrying this young man, and in the course of preparation, giving him instructions, he was not Catholic, giving him instructions in the Catholic faith and talking about marriage itself, I discovered that not only were his parents divorced, but two of his siblings were divorced. And so I felt it my obligation to address directly with him this question, because I thought it would easily be that not only would he have a certain acceptance of divorce as a part of marriage, if we could say, and the concrete marriage he was intending to enter. And so I posed the question to him in a kindly but direct way, and he responded to me immediately. He said, yes, he said, my parents are divorced, my siblings are divorced, but specifically because of what I've seen has happened in their lives, I intend to enter a marriage in which there will be no divorce. And so you can see, and there are other people I've known who, in their thinking, which I mean sometimes it's hard to understand, believe that people should have the freedom to divorce, but they don't. But their own intention to marriage is an intention for the indissolubility of marriage. This is simply the way it is. And so for us, the question is always the consent, And the consent is an act of the will. And so an idea of the mind in itself doesn't say anything about the consent until that idea of the mind has been reduced to a determining factor in the act of consent. Well, I hope that this has been somewhat illustrative to you with regard to this particular ground of nullity. Also, it helps with considering the ground of nullity of exclusion of marriage itself, which is very difficult to prove, but exclusion of one of the goods, essential goods of marriage. I simply conclude by saying that the tested and perennial principles of canon law and of canonical jurisprudence are the only way by which the application of the law is going to achieve the law's end, namely the safeguarding and promoting of the sacred realities of our life in Christ and the Church, and thus the salvation of souls, the safeguarding and promoting of the grace of marriage in the lives of the couple who have confected the sacrament for each other. Well, thank you very much, and we'll take a break, I guess, before we have our